966.
We are speaking now with Dr. Hamid Merah, CEO of the Saudi Center for Commercial Arbitration, which provides alternative dispute resolution in commercial disputes in the kingdom. Dr. Hamid, welcome. Thank you for joining the 966.
Good morning, and thank you for inviting me.
We're delighted to have you with us. Thanks for making the time. We were chatting beforehand and how fortunate we are because we first met in February. You were doing a presentation in New York City, and I came up to hear you. It was terrific. I wanted you on the show immediately, but it didn't work out schedule-wise. But this is perfect because just the beginning of this month, the SCCA, Saudi Center for Commercial Arbitration, has issued new guidelines for arbitration, a significant document and one that has been extraordinarily well received. And I'm hoping you can sort of tell us about how this came together and why it's important.
Thank you for inviting me and to be part of this great series of podcasts. Again, next year we will be celebrating our 10th anniversary. So it's coming together. And as you know, usually ADR, alternative dispute resolution, arbitration in particular, takes time. So because I call it the trust business. So what is it about? Arbitration, mediation is a trust. What we are selling is a trust. So we are also you can call us like a private court. The journey will start when you communicate with businesses, investors, local, international. They know about the center, then they have the trust, then they start including the model clause in their contract. Then if there is a dispute, then we can manage these disputes even through a mediation and arbitration or arbitration. So because of that, one of the most important elements in any institution arbitration center is what it called the rules, arbitration rules. Because it's like you can't say the guidelines, or not only guidelines, it's the way that all parties, tribunal, witnesses, expert, anyone, the thing that is drawing the way of managing the dispute with all of these parties is the rules. And also some other, great added value of these rules is, you can say, the efficiency it will add to the process. And instead, there is something called ad hoc arbitration, which is if there is a dispute, the parties, they will agree about all of these procedural things. The beauty in institutional arbitration, that institution like us in SCCA, that we are benchmarking, benefiting from the international best practices, and then to make it more efficient, speed, access to justice. Let me give you an example. We started the process. We issued our first version of the rules in 2016. And then we started the development almost 2 years ago. We formed what is called the Rules Advisory Committee, consists of 16 international experts from different parts of the world, chaired by Mr. Richard Neymar, the former VP of the AAA, the American Arbitration Association. So, and with different backgrounds, legal background like common law, civil law, and Sharia, different, you can say, even practical background, academician, lawyers from business sector, just to give that diversity and that enrichment to the process. Then we started by subcommittees with this advisory committee, and then they started to develop different parts of the rules, and then public consultation, public hearings, and also to start to hear from the businesses, from lawyers, law firms, until we ended up with the wording. So why the new rules? If you allow me, I would like to give different themes that we started from. We tried to enhance these themes by adding, adjusting, developing the rules to enhance these themes. If I can go randomly by some of that themes, maybe first is to enhance the governance. For example, one of the most important changes that we created is SCCA court. What does SCCA court mean? The SCCA court is an independent body within SCCA, consists of 15 international experts The president is Professor Jan Paulsen, Harvard, and from Sorbonne, and also he used to be the president of LCI, London Court of International Arbitration, the VP of ICC, one of the most well-known figure in arbitration globally. He is now the president of the court in SCCA. Two VPs, Dr. Ziad Sideri from Saudi, James Hoskin from New York, and again from all continents, from all backgrounds, and the majority of them, they spend big part of their life in institutional courts, such as the institutions that I mentioned. What is the role of this court? This court is to decide about number of technical administrative decisions, such as the appointment of arbitrators, challenging arbitrators, the replacement of arbitrators, the consolidation of cases, reviewing the awards, arbitral award, fixing the cost. For example, if there is any challenges related to the seat of arbitration, number of arbitrators, all of these technical decisions will be taken by this 15 international well-known experts to decide about that. So this is really important. This will enhance the governance, will enhance, you can say, the sustainability and of the quality of the work, and also these hundreds of years of experience. It will be supporting SCCA, you can say, practice. I will give the two other examples related to the governance. For example, the SCCA Code of Ethics of Arbitrators. Yes, it has been issued in 2016, but it was without teeth, as they can say. But now it's an integral part of the rules. Another thing also, the tribunal secretary provisions also now, it has been mentioned and made part of the rules. For example, this is the first aspect, enhancing the governance. If I go, for example, also to other aspect, which is the fairness and justice. For example, now the rules give the court the authority to refuse the nomination of the arbitrator by one of the parties. Or, for example, sometimes you can see sometimes really bad drafted contracts. For example, in some of these contracts, they will mention only one party have the right to appoint the sole arbitrator. This is against the justice. This is not fair. And sometimes if there is an arbitral award will go to any court, this will be annulled, will be set aside. So giving the court the authority to refuse some of these injustice, for example, clauses, one of the example to enhance the fairness and justice process. Let me give the third theme, which is parties' autonomy. We know one of the main benefits of arbitration is parties' autonomy. That parties, they can choose any applicable law, any arbitrator, any language, the seat, the rules, you can say the time, all of that. But in addition to that, in SCCA, the new rules, we enhance that autonomy, that the rules now expressly recognize that parties may be represented by foreign counsel. There were a doubt, can a party be represented by non-Saudi or non-lawyer? Again, the law and regulation in Saudi doesn't say anything, but now we enhance that, we make that very clear that you can choose anyone to represent you before the arbitral tribunal without any restrictions related to gender or, for example, nationality, or even if he or she a lawyer or not a lawyer. Maybe the fourth aspect, very quickly, enhancing the transparency and process integrity. Just, I will give one example. For example, now the parties can seek a decision from a challenge from the court and to be justified and reasoned. Now, giving reasons to that decisions also to enhance the transparency. Another very important aspect, we have now like a trend in the international arbitration, something called third-party funding or third-party funder. So now it's a mandatory on the parties to disclose if there is any third party has an economic interest in the outcome, because that will impact, you know, the process of the arbitration. So now it's a mandatory. If you allow me, just very quickly, I would like to go to the fifth theme, which is
Definitely.
enhancing the speed and efficiency. For example, now the case management conference shall be conducted within 30 days of the tribunal constitutions. So now we have different timing. It wasn't that clear in the previous version of the rules. Now there is very clear deadlines about, for example, the case management conference, the constitution of the tribunal, and also one of the things, if you have something called emergency arbitration, we appoint the arbitrator within 1 working day, and even that the parties, they can apply for emergency relief even before they apply their case, just because, as you know, if you have a big case, sometimes it's very sophisticated, complicated, and you need time to be prepared. So giving the parties that the authority or the ability to request for emergency relief even before applying their case, but to follow the case after 10 days. These I have maybe here 7 examples, but just for the sake of the time, I gave just 2 examples related to speed efficiency. The second aspect or theme is green arbitration, digitalization, and support of technology. Again, SCCA is investing heavily in technology, not from today. We launched something called the online dispute resolution, which is 100% virtual mechanism to in arbitration for tiny and small cases. For example, one of the changes, it was opt-in. That means if the party, they would like to use ODR, they can, but now it's opt-out. That means if the case within the threshold that we have, it's directly, automatically, it will go to the ODR. The ODR, we launched the online dispute resolution even before the pandemic. It was in October 2019. So we are investing heavily in technology. Just one of the things that we add to the new rules, that starting from applying your case, you can electronically deliver your request for arbitration. The hearings, now we gave the authority and the power to tribunal to decide if they would like to hold the hearings virtually. Also submitting, you can say, the arbitral award electronically. Also recognizing the electronic signature. So starting from applying the case, you can say the memos related to the case, the hearing, and also the arbitral award, and also recognize the electronic signature. All of that is showing consistent support of digitalization and green arbitration. Finally, also we mentioned the some details related to cybersecurity and the details related to that. Finally, or maybe 2 final aspect is the response to increasingly complex dispute. This is inconsistent with the rising caseload of SCCA. By the way, yes, this is maybe the 6th or 7th operational year of SCCA, but we are proud to share that our caseload is well diversified. The parties or the disputes that we managed and filed in SCCA in the past 7 years from 21 countries, starting from North America to Europe, Sub-Sahara, North Africa, Middle East to Asia. In addition to that, also the diversity in terms of industries. It's also from almost 20 industries. The biggest part of our caseload is construction. Almost 50% is construction, to logistic, to financial services, pharmaceutical, advanced technology. Going back, we see more complex cases. So there is now a need to have a very clear path for multi-contract dispute, multi-party dispute, joinder, consolidation, and also to arrange between cases at the same time. So not only we added clauses, we added a complete chapter in our rules, which is chapter number 2, related to these kind of cases, which is again great added value to our users, especially the cross-border disputes and huge dispute. Finally, one of the things that we did in the recent development in the rules is to make a substantial differentiation between the substantial law and procedural law. As you know, usually the rules is a procedural part, managing the procedural part. So in the old version of the rule, there were a mention that the parties, they have to comply with Sharia. And as you know, Sharia related to the substantial part of the cases. So we took that out from the rules, and now we kept the rules without anything mentioning any substantial part and Sharia as an example. At the same time, we know, for example, like Islamic finance industry, some other, you can say parties, they are eager to be in comply with Sharia. We added like a model clause in by the end of the rule, they can use it if they want. Sorry, maybe I talk much time, but I try just to give an example of the themes that we try to cover. I'm happy within less than a month, almost 20 sophisticated review and articles has been published by different international law firms, the biggest international law firms. They wrote articles and review just in the past 3 weeks, just to show the importance. And all of these reviews, without exception, all of them, they are mentioning how sophisticated, how advanced, world class, the best practices, and also to show the leadership of SCCA, not only in Saudi but in the region. And also that came after the step that we took just in January to open our first regional office outside of Saudi in the IFC in Dubai.
So let's talk about this, because it was just released and published at the 1st of May, and you're right. We carried a number of articles about the SCCA new arbitration rules in our newsletter. One of them was by the National Review, very positive. So, and this is what you're hearing. It's been a very good response to the new arbitration rules.
No, that even from users, I mean, big corporations. And to be honest, that wasn't a surprise, because as I mentioned, it was very important part of the development of the rules that, the public consultation and also the workshops that we had with corporations, with law firms. So there were a very clear dialogue, and we developed the rules based on their need. So it was well received from the community, in terms of law firms and also corporations and users.
You mentioned a regional aspect, and as you also mentioned when we were talking, that there's a variety of guidelines and rules, and on arbitration and dispute resolution, a lot of different ones. How does this work? So in Saudi Arabia, obviously, this is the transcendent guideline. This is the framework. But there's regionally, how does SCCA take this and sort of try and make it more uniform regionally?
Very good question, Richard. Let me be very honest. I think there is big number of institutions globally and in the region, and I know big part of it's big or small part, but at least there is businesses and cases from the region, Saudi and GCC countries and Middle East in general, traveling to some centers, for example, to Europe, to London, to Paris, and some other centers. What is the added value of SCCA? We tried to think the vision that we started early in the first day before we opened SCCA office is to be the preferred ADR provider in the region by 2030. Very, very optimistic and challenging vision. But that vision has been set not to be just a bureaucratic part of, establishing an institution. It has been set to be achieved. And achieving such a promising, challenging vision needs to have a very clear, you can say, strategy, business plans, KPIs to achieve that. Before I go to that, I would like again to go back to your question. What is your added value among these number of centers? I can summarize it in 2 words, Richard. The first one is what can we call it? Working within or developing what called ecosystem. If you develop a very sophisticated world-class center, it's very important, but it's not enough. If you don't work within an ecosystem, you will not be able to achieve that very challenging vision. Assume you have very good center, very good team, very good rules, but by the end of the day, if you don't have a very supportive judicial system, by the end of the day, your arbitral award is just an ink on a paper. There is no benefits. And by the end of the day, you need this to be enforced efficiently. So, first of all, and I will shed light about what I mean by ecosystem and what we have done in that regard. But let me go by the concept. First of all, to work and develop an ecosystem, not only in Saudi, in the region. Number two, what we call it, maybe it's a new word in English, the glocality. I mean to be glocal, global and local at the same time.
I love it.
So what do you mean by glocal? What I see, Richard and Lucian, in some centers here and there, you can find some very global center in the region, but they come as they go. They spend 10, 15 years but it's a closed club. There is no impact in the community. And what is the difference if you have a center in, for example, in London and Paris or New York or somewhere else, and you have the same center, for example, in one of the cities in the Middle East? If you don't have that mix, a real mix, I don't mean, for example, to have like messenger or clerk here on there. No, to have an integral part of that center, mixing the international experience with the local caliber from all levels. That is not there. Or in the opposite, that you can find a lot of local centers, local people, local knowledge, local understanding, but you cannot have the international best practices. And here is the gap. What we could do and what we are doing is to be able in practice to be a real global, the best international practices, and you can find the best people in the board, in the court, in the advisory committee, case management team, managerial team. So in all of that bodies, you can find a real good people from all around the world. Number two, in the same levels, in all bodies, you can find Saudis, Khalijis, Emiratis, Arabs, and international. Not only because they are international, because they are the best people globally. You can find both of them. So what does that mean for? Is just for a show? Is it for BR? No. This can say combination, this recipe is converted into trust. What I mean by trust? Trust from judicial system. When you have an arbitral award stamped by SCCA, the trust that you can have from judicial system could be translated in more efficient, more trusted awards. And that means your possibility to have your award enforced is higher, faster. And that means a lot in money for you as investor. And also when you have this kind of combination, what does it mean for an international investor and even local investor? That we can help you to understand the culture, to understand the laws and regulations, to understand, you can say, the needs in the region. So this is a great added value. This is a safeguard to your businesses. This is a safeguard to your, and that means a lot of money. So this is the added value to SCCA. Because of that, we saw an interest. So we expanded our work now. We have our regional office in DIFC, and it will not be the end. It will not be the last office. And as you know, the most, the offices, the physical attendance is not that important, because you can have like investor coming from New York or from Paris or from Canada or from Kenya or China. As soon as you add the clause for SCCA, you can have any applicable law. You can have any procedural law. You can make the bleeding and you can process in any language. And this is great added value. And just yesterday, less than 24 hours, we signed with the Authority for Special Zone and Economic Cities in Saudi Arabia to be the main provider for ADR. We will have offices in King Abdullah Economic City, and we will have in Ras Al Khair in the north and in Jazan in the south. So to be physically supporting the FDIs, the international investors. So we are your partners, and this is one of the main enabler for FDIs, for investment, for businesses, and for the access to justice, generally speaking.
That's a really interesting linkage, and because those are two very important initiatives in terms of the Saudi economy and in terms of attracting investment in particular. So we've in the last 3 months, I say, Lucian. So we've had James Golson, who's the senior commercial officer with the U.S. Embassy. You may know Jim, and we've had Steve Lutz, who's the Middle East head for the U.S. Chamber of Commerce. Both of these gentlemen essentially advocate for U.S. businesses, and of course this is very close to our hearts. We, in terms of the relationship, U.S.-Saudi relationship, we feel like the commercial relationship is critical. So what you're saying is under this new regime, under these new guidelines, and you spoke specifically about trust. So when Jim and Steve, our good friends, go and talk to prospective investors, they can reliably say, all right, your arbitration, your dispute resolution in Saudi Arabia is significantly enhanced now, and therefore it's going to be more attractive, correct?
Yeah, 100%. Not only, for example, the business in Saudi, and this is the beauty. For example, if there is a US company investing, for example, in Iraq, investing in Jordan, investing in North Africa, so we are from the region. We understand the culture. We are respected and trusted. So you can have this neutral center speaking the same language. I don't mean only language English, but the same jargon, the same, you can say, concept. Our rules is based on UNCITRAL model rules. So anything that you are familiar with in AAA in New York or in LCIA in London or ICC in Paris, you can find it. The arbitrators, the best arbitrators globally, that you can hire them to manage your case in all of these centers, you can find all of them without exception in SCCA. So the added value, you have a neutral world-class center, trusted, understanding the culture and the region, not only in your businesses in Saudi, in all your businesses in the region. So that is really important aspect. And maybe we are helping more the businesses in the region, because if US company have a business in Kuwait or Iraq or wherever in the region, it's much easier to have this an independent, neutral center. And we start, for example, we signed with DIFC courts, and we have good relationship, for example, with Saudi courts. And more importantly, and this is a really important point, Richard and Lucian, that Saudi is a signatory to New York Convention. What is New York Convention? Is the convention to recognize and to enforce the foreign arbitral awards. Now 171 countries globally are signatories to that convention. That means if you have an arbitral award issued by SCCA, it's easily and efficiently enforced in 171 countries globally. If you have a judgment issued in any of these countries, you'll not be able to enforce it that way, because you have to have double treaties. But an arbitration is just one side relationship. That means just as soon as you join New York Convention, the arbitral award is enforced globally. So you don't have to bother yourself by these treaties. Issue the arbitral award. We understand your culture. We understand the culture, the language. And number two, the best international practices, the best rules, the best court, independent, impartial, efficient, trusted in the region, judicial systems. So, and you can enforce it in all around the world. So these, you can say, package of services is catered to help you, especially as a foreign investor, not only in Saudi, in the region generally.
This is fascinating. So if I'm a U.S. investor and I'm doing I'm looking at an investment in Iraq with a partner there, we can agree that any dispute resolution will be handled by the SCCA.
Exactly, and that means it doesn't need the hearings needs to be held in Riyadh.
Right.
The hearings could be virtual and could be held in any place all around the world. And the language, choose any language. Applicable law, choose any applicable law. The procedural law, choose any procedural law. So that will help. Because of that, we are working now in DIFC. So, for example, the people now, I see a trend, for example, in companies, for example, in the region. For example, they choose SCCA as an administered institution, and the case will be administered under our rules, and the applicable law, sometimes the English law, and the procedural law is DIFC, and the seat is DIFC. So if there is any challenges related to the arbitral award, they will go to DIFC courts, or maybe the newly established court in Bahrain, which is called the International commercial court in Bahrain. So the globe is, and even they can agree on the New York courts. So that is open. All of that flexibility is adding great value to the investors.
So are you anticipating a growth in cases? For example, how many cases is SCCA handling now, and how many do you anticipate?
Great. So I can say SCCA caseload is one of the fastest growing caseload globally. For example, last year, our caseload increased by 60%. Up to date, we are almost surpassing the overall arbitration cases has been registered last year, not only the numbers and even the value. We saw cases in billions now, and the diversity in terms of industries, nationalities, sizes, and jurisdictions. So all of that is aspect about trust. And by the way, I don't know if you have seen the Department of States in the US, they issued a report about business environment in Saudi Arabia, maybe 1 year or 1 year and a half, something like that. One of the things that I saw, they mentioned it 3 or 4 times in that report. One of the most important enabler is SCCA and the arbitration regime that we are creating. So this is really important aspect. So SCCA now is managing big cases, international cases, sophisticated cases, and number of cases and value of cases is fast growing.
Just tremendous. Lucian, you've covered everything, Doctor, and really clearly and thoroughly. I think this is a fascinating discussion. As we said, we wanted to have you on and we wanted to talk about the SCCA because we think it's very important. But in the telling of it, and you're sharing with us, I mean, I think it really affirms what a central role it plays and what a facilitating role it plays. And this will be interesting. You as CEO of SCCA, you have a lot of hats. So there's a strategic hat. I'm sure you oversaw this whole process of updating the guidelines. You may have to expand your staffing now. And in terms of the SCCA court, does this sort of police and monitor itself? In other words, you have the 15 luminaries, and it really is an impressive group. How do they work together? And is there, for example, are there clerks? In other words, like the administrative side of what they do? Who handles that? Is that SCCA thing, or is that an SCCA court thing?
Great, thank you. If you allow me, just I would like to go a little bit zoom out, just to show the different bodies in SCCA, to show the governance. First of all, SCCA is not for-profit organization. We are not related. We are not reporting, not part of the government, and at the same time, we are not part of the private sector. So, not for-profit organization. And the ultimate authority of SCCA, its board. Our board, 40% of our board, non-Saudis and expert from private sector and from the legal and ADR community. So this is number one. So, and the board, the board, yes, the majority of them lawyers, international arbitrators, but their job is to supervise SCCA strategies, annual reports, also to approve rules, but they don't have any clue about case management. There is a Chinese wall, so even they don't know even the names of the parties. They don't know any information about the cases. Only stats, general stats, how many cases, volume of cases, nationalities, even the information that even we publicize, the public information. So there is no role for the board in case management, which is really important, and this is the best practice. So we have the board, the ultimate authority. They appoint the CEO and the in-house team, the full-time job employees under my management. So we are reporting to the board, but they don't have any clue, any relationship with the case management. We have the Rules Advisory Committee, again, 16 members, international figures. Their role is advisory, and they help us in developing the rules and services. For example, we have something called expedited procedure, which is, you can say, arbitration for medium-sized disputes and SMEs, which is cheaper and faster, cheaper by 30% in cost and time compared to regular arbitration and the cost of it. we have something called ODR for tiny and small dispute. We have emergency arbitration. We have mediation. And also we have virtual small mediation for small cases. All of that products is the advisory committee will help us in developing all of these products, including the rules. But again, they don't have any interference in case management. Number 3, which is very crucial and just recently launched and they started their work, is the court. The court is independent body and their decision is final and binding. And the board, they don't have any interfere in their work. So they are independent. All of these things has been mentioned clearly in the rules, which is appointing arbitrator, replacing, all of that, very crucial administrative technical decisions will be taken by the court. The case management team, what we call it the ADR team here in SCCA, we have a good team, well-qualified team. They are called case manager. They are supervising the implementation of the rules, but they are like a coordinator with the court. The court will take all of these crucial decisions related to the cases. Again, the things that I mentioned. So the court will take care of these decisions. My team, the case management team, they will implement these decisions and to supervise the implementation of the cases. And we have finally the arbitral tribunals, which is the arbitrators. They will decide about the substance of the cases, right, wrong, who has the right, and to pay how much. All of these decisions related to the substance of the cases, it's the authority of the tribunal. But the administrative, technical decisions, for example, if you would like to challenge, if you have, for example, one of the parties, they said, this arbitrator, there is a conflict of interest. Who will decide? The court will decide. So this is the map. This is the high level of governance and strict governance with these bodies, just to show how can we manage this institution. And this, by the way, this is the international best practice in all the international big institutions that they are doing almost the same concept.
So, and now that leads me to another question: are there enough qualified arbiters?
Yes. Again, one of the beauties of arbitration, the word is the limit. So we have in our roster almost arbitrators. Let me share with you the exact numbers, just to know the diversity. We have more than 400 arbitrators speaking from 26 nationalities, speaking 19 languages, specialized in more than 20 fields. That means any arbitrators, good arbitrators that we have an access to. And again, even if there is 2 parties, they would like to appoint, if they agree on any arbitrators, even if the arbitrator is not in our roster, we encourage them to do that. Because the arbitration is, the concept of arbitration is parties' autonomy, that we encourage them to agree on the arbitrator, even if the arbitrator out of our roster. Right. In addition to that, we have a strategic partnership with different organizations globally. Also, part of that is to have, the mutual access to our rosters. So, for example, if we have very niche or very sophisticated area, and for example, assume hypothetically is not in our roster, we can reach out to our partners, these institutions, and they can do the same in our roster. So there is no issue at all related to arbitrators, because we can reach out to any arbitrators globally, and already our own roster is rich enough in all of these aspects. Richard, I know if you allow me just to go to shed light about the ecosystem and the pillars.
Yeah.
Yes.
Sure. Absolutely.
Yeah. Just I mentioned about the ecosystem. If you allow me, it's, in my opinion, it's 5 pillars. I will mention very quickly. The first one is the legislation. You can say responsiveness. That you have to have the laws, regulations related directly to arbitration and mediation, ADR, or indirectly, needs to be developed, and the country needs to be agile. If you look at Saudi in the past 4 to 5 years, it's very active in developing the legislative infrastructure. For example, in the past 4 or 5 years, a lot of laws, regulations. Let me give you just one example. In the past 50, 60 years, governmental entities, semi-governmental entities, they were restricted from, referring their cases to arbitration. One of the main changes has been done in the past 2 to 3 years. First of all, there is a royal decree in January 2019 to encourage governmental entities, semi-governmental entities to use arbitration in settling their disputes, especially with foreign investors. And SCCA was mentioned there. But see, from restricting to encouraging, see the difference. And then the new governmental tender and procurement law has been enacted in August 2019. And few months later, the implementing regulations, in a state of requiring the governmental entity to grant a license on approval from the cabinet, now only to have the approval from Ministry of Finance. Further step, which is the second pillar, is governmental support. The Minister of Finance, under his authority, he approved what it called the 17 or 18 model contracts, infrastructure, different contracts. All of these model contracts, the model clause is institutional arbitration and SCCA in particular. See the huge difference from to be restricted to use arbitration to have institutional arbitration and SCCA as a default clause in your contracts. See the huge shift. And that is two components, is legislation development and government development and support. The third very, very important element and pillar is judicial support. So to reach that, different initiatives has been taken with the judicial system and the Minister of Justice. For example, we started an initiative by signing a cooperation agreement with Minister of Justice in 2019 for SCCA to provide an advanced training programs to the related judges. So we did, for example, the last episode was in December 2022 in cooperation with the Ministry, with the ONCITRAL and NCC, the National Competitiveness Center, and Minister of Justice. One of the international well-known figures, Prof. Muhammad Abdul Wahab, conducted that for 2 to 3 working days. It was great, training. For example, another one, we started 2 years ago to analyze the judgments out of the Saudi courts related to arbitration, called Case Law Project. And I encourage all our audience to follow these results. We announced the result, the first one in November 2021. In 2022 November, in Dubai Arbitration Week, we announced the result of the second version of the study. And if you allow me, I would like to share some outputs. We found one of the concerns: how is the percentage of the courts to annul arbitral awards? Usually, globally, one of the parameters to see if this country or judicial system is pro-arbitration or arbitration-friendly jurisdiction, if the percentage of annulling and the arbitral award is higher, that means they are less friendly jurisdiction. We were in Paris Arbitration Week few months back in March, and we found there is a study. The percentage in Paris is more than 20% to annul arbitral award. The study that we did for more than 720 judgments out of Saudi courts in the past 3 years, the percentage of the successful annulment is not more than 8%. 5% a complete annulment and 3% partial, which is great. See the comparison. Another aspect, what the role of Sharia, especially for foreign investors, one of the things they are not familiar with, they are afraid of, is our arbitral award will be set aside in Saudi because of Sharia. What is Sharia? We found, as per the study, and this is published, the annulment based on Sharia compliance or public policy, not more than 3.8%. Which is nothing. So globally, every country, as per the New York the New York Convention, any country, they cannot enforce the foreign arbitral award if it's contradict with the public policy. So all around the world, but the thing that you need to see consistency and predictability. This study shows that Saudi court is supporting arbitration and it's consistent and predictable. And just recently, we published the stats that we received from Minister of Justice about the enforcement of foreign arbitral awards. just in few seconds, in the past 7 months, more than 244 arbitral award, local and foreign arbitral award has been enforced in Saudi. More than 234 million US dollar in the past 7 months. We compare this stats to the stats of the first 9 months of 2022. The monthly average number in the past 7 months is surpassing or increased by 29%, which will show you, the percentage. Why the number of cases, the arbitral award, the enforcement or arbitral award in Saudi increased? For 2 reasons. The trust. Number 2, more the people, they are going more to arbitration, even local and international. And number 3, the trust in the system. So that I know it will be efficient. I will get my money efficiently and I can predict, and that means an added value to investor. Go back to the pillars: legislation responsiveness, governmental support, judicial support, and I show you through different initiatives, we started to show the output, the result of that investment in numbers. 4th is independent world-class center, and we should light about that, about SCCA and about the governance and all of that stuff. And finally, and the need in our region is more for this pillar, which is the training, capacity building, awareness. The first institutional center, arbitration center in Saudi, Richard and Lucian, is SCCA. That means the industry is very young in Saudi. And in the region, generally speaking, comparing to some centers globally, they are 100 years plus. So to be able to have world-class arbitrators, and as you know, the cornerstone for the process is the arbitrators. By the end of the day, they will decide. They will issue the arbitral award. So you need very sophisticated, you can say, professional arbitrators. Because of that, we started different initiatives. First of all, we launched our academy. We started with the best global, training partners like the Chartered Institute of Arbitrator in England, with AAA in New York, with the RICS in London, so with CLDB in the US. We started with them different sophisticated programs in arbitration and mediation. We did another very important game changer initiative, also supported by UNICITRAL, supported by CLDB, Chartered Institute of Arbitrators, which is the International Arbitration Moot Competition in Arabic. The first edition, we had only almost 36 teams from Saudi. This edition, 2022-2023 edition, the 4th one, we have, let me share with you the stats from, the report. We had, believe it, in the 4th edition, we had 110 teams, 780 students and professors from 20 countries, from 60 plus cities. Believe it. All of these students, the future leaders, they opened their eyes related to arbitration through SCCA, through SCCA rules. And again, it's not just a competition. We conduct with UNICITRAL, with these global bodies, not less than 4 to 5 sophisticated training courses only for them and for their professors. We help them. We assign, if they cannot assign coaches, we assign coaches for them. Because it's not just a competition, it's a complete 8 months of development for them. So I saw a lot of them, they said, they swear the 8-month competition is worth a master. It worth, can say, I saw some of them as part of the international law firms. They said, I saw just recently one of them, he said, Ahmed, now I'm a lawyer for a year, because he was with us in the first edition, and I was part of, you can say, billions cases. The intensity of work until now, I haven't seen such that 8 months. So Richard and Lucian, we are investing in the future. We are investing not only in Saudi, we are investing in the region. If we have developed region, sophisticated region, successful region, judicial, lawyers, arbitrators, SCCA will be successful, Saudi will be successful. Because again, this is the vision of Saudi. Saudi Vision 2030 is not only for Saudi to be, and His Royal Highness, the Crown Prince Mohammed bin Salman, he is repeatedly mentioning what we are trying to do, not only to develop Saudi, we are enhancing the quality of the whole region. We are working to have new Europe in the region here. So we are part of that vision. We are inspired by His Royal Highness Prince Mohammed bin Salman and the vision. And to be honest with you, Vision 2030 changed the paradigm. It's a paradigm shift even from mindset. So let all of us work hard to take the best out of us. So these initiatives, these things, we will not be able to do all of these initiatives without the environment that we are working in, which is 2030 vision. And also, we are not only working for Saudi, we are working for the sake of the development of Saudi and the whole region.
The absolutely brilliant Dr. Hamid Merah, CEO of the Saudi Center for Commercial Arbitration, SCCA. Doctor, please come back and join us again on the program. You're accomplishing so much so quickly. And I know what you're doing is so interesting to our listeners and viewers. And so congratulations on all the success so far. And thank you so much for joining us. This was fascinating. This is awesome.
And Richard, it was a great opportunity. And for sure, I will be more than happy to accept any invitation in the future. I was happy that when Richard told me how many episodes and how many guests, I saw there is some guests were invited for more than one, for mathematical result. That means that there is a room for SCCA to be part. We are really happy to be part of that and part of our job. Reach out. Please don't hesitate at any time. If we can add value, we will be more than happy to join.